emissions insurance, have fidelity bonds. Has the county gone after these errors and emissions insurance, gone after these fidelity bonds to see if they can fund the settlement? That's a question.
Apparently not.
Is silence the only answer I'm going to get?
Jim?
I've already told you, in writing, that no, the county is not. And that unproven allegations, until you go to a court of law, a criminal court of law, and determine that there are, in fact, errors or fidelity issues, you can't make a claim.
Would you say moving a high water mark 20 feet seaward would be reasonable? And you've got a copy of that letter somewhere on record. That's not unchallenged. That's probably something that we can decide today if the evidence was brought in. Or if you were to ask to impanel a grand jury, let them get to the bottom of this. If it's too hot potato to handle politically, bring in a grand jury. It's easily done. Also, I take issue with some of the legal advice you're getting. First of all, I like Martin Nichols a lot, but any of you should know that he has a conflict in advising you. His entire office has a conflict in advising you on how to deliver this, or how to settle this. Also, the mediator that you have, who is also the lead negotiator, lead person for the county's risk pool, he's not going to advise you to throw this on the risk pool because he has a conflict. So that's why it's thrown on the taxpayers all of a sudden without even exploring these other ways to get it funded. So why don't we try and get all of these other potential funding sources discovered, at least investigate them, and then deliver a complete report to the county taxpayers saying, we couldn't get any other type of settlement funding for this, so we're going to have to go to the taxpayers. But don't go to the taxpayers first. We're tired of that. It's happened too many times, and it's probably going to happen too many more times, unless and until you get to the bottom of this. Mary Ellen, I think you've done a beautiful job in getting this deal put together. I think it is the best we could have hoped for out of this. So I'm not trying to say, let's don't do this deal. I'm saying, let's put the responsibility for funding this deal on the responsible parties. I'm so glad we're going to get a park out of this instead of nothing. But let me share this with you. Mr. Lane would have provided that park free of charge if he had ever been treated with any respect by this county. But instead, for 17 years, he's had his requests slow walked or ignored or put down to some kind of rabbit hole. That 1999 report that I was talking about, it was mislabeled, as several of these records have been mislabeled, and it was put in storage as a research paper. Now, if you're looking for a consultant's report on how taxpayers are treated, you're probably not going to look under a heading called research papers. So I say that there's been a conscious effort to obfuscate and perhaps hide and cover up these requested records over senate. And there's nothing on the record that I found that would disprove that there has been an active cover-up involved with this for at least 17 years. I'm almost. Just give a little background. When Mr. Lane bought this property, and as I've already said, he mentioned that he had tried to find out if it could ever be developed, and they told him no. And so he wasn't a full-time resident, and so he came back one day, a year or so after he made the purchase, and he realized that there was development going on across the street from him on this lot that could not possibly develop. And so that's right then when he started trying to run down the internal dialogue between the county as to how this thing got permitted. Stonewall. Couldn't get the information. And so he decided he would have to go after Mr. Sedlak, who built the property, and in his mind built it illegally because it couldn't be permitted. And then when he tried to get the information from the county to buttress his lawsuit, couldn't get it. So he had to go against Mr. Sedlak, and because he had worked for 2 years to try to get this information from the county, he couldn't get it, and so he failed in his lawsuit because of the statute of limitations had run. So now, because of his disagreement and his accusing Mr. Sedlak of building an improper building, then Mr. Sedlak, when Mr. Lane got ready to build his home across the street from that property, then Mr. Sedlak was over there taking measurements and called the county, and the county went out there and made Mr. Lane move his foundation back 2.5 feet. but never concerned themselves with having Mr. Simplak get all of the waivers and all of the permissions that he needed in order to do his. So the entire apparatus of county government moved against Mr. Lane, when all he was trying to do was to get the county to obey and to get the county to enforce its own codes and its own laws and its own shoreline master plan. None of which ever occurred in this situation. Once we answer the question of how we got to this sorry state, then we've got to put the responsibility and the funding on the back of the responsible parties. And I also want to add this, before you get ready to fund this like you're talking about doing, I have personal knowledge that there is what they call a private attorney general act in federal government that can take all of these situations that we're talking about here and sue the county. And I think it's $1,000 a day for every day that the county allows that building to stay where it is. Even after you get this grand plan settled today, as long as that building stands there, you become the successor liability, and it's going to be $1,000 a day for every day that that has sat there, and for every day that it is sitting there until you move it out to Salt Creek or wherever you move it to. With this $500,000 plan, does that include picking up this building and moving it to Salt Creek, doing the plumbing, setting the foundation? We don't even have nearly the final cost of this plan. So, I urge you, transparency. Transparency. Have the responsible parties made responsible. Thank you.